Hello, everyone, and welcome to the Ledgers podcast. My name is Chantal Cleland, and today with me, I have Seth Doe Esquire.
Thank you.
Seth is a lawyer as well as a mentor to many law students, just like myself. And today we're just gonna have a casual conversation about everything law and law school. So I'm just gonna ask him a couple of questions. So, what is the process to become a lawyer, especially here in Ghana, within the Ghanaian jurisdiction?
Right. So the process of becoming a lawyer in Ghana is basically starting with a law degree. And that's what is going to be used to get the professional training. Now, the law degree is obtained in three main means, either as an undergraduate or a postgraduate or maybe a foreign student.
Okay.
So the undergraduate is very privileged because that person goes right from senior high school. That is the first degree you obtained. So in Ghana's jurisdiction, you are allowed to obtain a law degree even right from SHS. And I think that is very good news for those who are really young and want to start this law career early.
Yeah.
So right from SHS, you realize that the student enters the university that is accredited by the General Legal Council with having the necessary resources to teach the law courses like constitutional law, contract law, Ghana legal system, tort law, criminal law, and others. So what then happens is that the undergrad will go through a period of 4 years to obtain the law degree from the accredited institution. You're a postgraduate because you've already attained a degree, and that is known as your first degree. So the law degree, that is the LLB, is probably your second degree.
Yeah.
So as a postgraduate, what's important to understand is that the period might be relatively shorter.
Yes.
That is a 3-year period, or maybe in some institutions they can have a 2-year period, but it's usually a 3-year duration where you would learn the same courses with some electives. So the main courses are constitutional law, Ghana legal system, contract law, the law of torts, and others. And then the electives can be natural resource law, international human rights law, environmental law, and others. So when you learn these courses and you pass the exams per semester, you would be deemed accredited, and you would have the necessary certification, that is the LLB. And with the Bachelor of Laws, you can use it to write the Ghana School of Law entrance exam to get the qualified professional training to be a lawyer. The third particular person who can also be trained to be a lawyer in Ghana is the one with a foreign LLB or anything that is similar, especially from a Commonwealth legal tradition. So, especially from a common law legal tradition.
Yeah.
So, what happens is that probably someone from Nigeria, someone from Gambia, someone from Zimbabwe, in Africa, the English-speaking countries were mostly colonized by the United Kingdom.
Yes.
So, in essence, they have similar legal traditions as the common law. That is the common law legal tradition. So, when you obtain a law degree from these countries, then you can now apply to write the Ghana School of Law entrance exam to come to Ghana and also have the 2-year professional training.
Right.
So the next step after obtaining a law degree is to write the Ghana School of Law entrance exam to enter the Ghana School of Law. Now, the Ghana School of Law is the only institution that has been accredited with the particular authority because they have the resources and they have the legal personnel and the lecturers and all that to undertake the professional training.
Okay.
So the professional training is usually about a 2-year period for anyone who writes the Ghana School of Law entrance exam. So after writing the entrance exam, if you pass their pass mark and you enter the Ghana School of Law, it takes a period of about 2 years. Now, there are some courses that are professional courses like civil procedure, criminal procedure, the alternative dispute resolution, company and commercial practice, legal accountancy, law practice management, courses like family law and others, interpretation, law of interpretation and others. So these particular courses are a bit professional because they are more practical.
Yes.
The constitutional law, the Ghana legal system and all that are more or less theoretical courses. Yes, that's true. So the practical ones are really taught in the Ghana School of Law. You go through some process of mandatory internships with law firms or courts. Right, a student would have to go through some internship by maybe visiting the law firms, working with the law firms, or visiting the courts and working with the courts. So what then happens is that when you get the mandatory internship training and you get the particular professional training, you write the bar exam. That is the end of year exams for each professional student who is taking the professional course.
Right.
At the end of the bar exam, you'll be accredited with a license from the General Legal Council. But then you must even be a student of good standing. And that is not even enough to make you a lawyer. You still have to go through a mandatory 6-month period. That is the pupillage period, where you'll be under a lawyer with 7 years practical experience. The lawyer will take you through some practical aspects also, how to relate with clients, how to do the drafting itself. And you are already a lawyer, but for the license to practice, you need to have the mandatory pupillage done. Right. And when the mandatory pupillage is done, you also have your pupillage license, and now you can deem yourself a fully qualified lawyer to practice in Ghana. The final option is for a few students who already obtained their law license abroad. They will come into Ghana to have training on the Ghana's legal system. So it's usually relatively shorter. You come to the Ghana School of Law. Within 1 year, you go through the accreditation to learn Ghana's legal system. Okay. Once you do that, you'll be deemed to be a qualified lawyer also. You'll be called to the bar, and you'll be deemed to be a qualified lawyer after the mandatory pupillage. Thank you.
Okay, so thank you. You mentioned that there has to be a pass mark. I have some, not to digress, but I have some doctor friends when they were in medical school, like during my first degree, they kept mentioning, oh, you have to do the pass mark. At first it used to be 50%. I think now it's 60%. So, and then now that you've mentioned the pass mark for the macula exams, entrance exams, what is the pass mark per se that one needs to pass to enter into macula?
Well, that's a very important question, because the Ghana School of Law entrance exam wasn't even something that occurred when the Ghana School of Law was established. This exam is, let's say, relatively recent. I think it probably started from 2012 or 2013. Now, what happened was that with the high intake of law students and the number of institutions that were accredited to grant the LLB, many students were applying to enter the Ghana School of Law because they must obtain their professional training from only one institution. So the Ghana School of Law, got particular authority to run the Ghana School of Law entrance exam, to conduct that exam. And that exam is even conducted by the Independent Examination Council. So the pass mark is not really set by the Ghana School of Law. Okay. The pass mark is actually set by the Independent Examination Council. They will mark the papers. So there are lawyers that are separate, or professionals that are separate from the Ghana School of Law.
Right.
Now, in essence, the pass mark was usually 50. The issue was that the exam was less than 2 hours, and the main courses will be examined. That is your constitutional law, your legal system, your contract, your law of tort, your immovable property law, and even your criminal law. But then it's only within 2 hours. Everything you've learned in those 6 courses is within 2 hours. So there was a bit of pressure on the students to write and pass the exam.
Yes.
So it seems that since the Ghana School of Law, the Independent Examination Council has the authority to decide what the pass mark is, it has actually been in a range. Right. Sometimes they say 50%, mostly it's 50% out of the complete 100% score. But then I think recently, either this year or last year, they actually stated that it should be 50% per question. Okay. So you need to actually pass each particular question and obtain the 50% pass mark. That was the issue in there. So it becomes more or less discretionary. Even students will have to sign a bond and state that they accept whatever decision has been made by the Independent Examination Council. Sometimes you don't even know the pass mark. You will just know that you've been passed, or you just know that you failed. So in essence, it becomes more or less a discretionary power. So you can't really state exactly what the pass mark is. Wow. But usually a student who wants to pass should aim for getting more than 50% of the natural scores. That's the 100% full score. I think that's the best means to make sure that you are qualified to enter the Ghana School of Law.
Okay. Thank you. So this leads into my second question. As a law student, when people I meet for the first time, or some of people from maybe home at church, they find out that I'm studying law. They're like, "Is law school difficult? Like, is it worth it? Like, what do you think? What, in your opinion, makes law school difficult?"
Well, law school is difficult because people just enter. That is the truth. Now,
But not to interject, I remember there was a video going around of the Chief Justice herself saying, like, the law is difficult. That's why law school is difficult.
yeah, so you just enter law school without the proper training, or you don't even. And if I say the proper training, I'm saying that as a law student, you have to actually learn how to study law.
Yes.
So I usually post my transcript or share my transcript to encourage law students because I'm a mentor to many of them. The issue is that when you start your first year, it's actually hard. But it's not expected to be hard continuously. You are expected to learn certain things. And most students actually do not try to engage themselves to learn those things. Now, when I got my mentor in my second year, who was a practitioner, a lawyer, he taught me the method that good students use, and he mentioned it as the SMART cane method.
Okay.
So for the SMART cane method, the S stands for the study guides.
Okay.
Right? Law students are supposed to learn how to prepare study guides. Now, if you've written a law exam, you know that the day before the exam, you want to compile all the notes in some small jotter or in some small notebook, the principle and the authority, the principle and the keys, so that you just quickly read it. So you must learn how to prepare study guides in advance. That's a tip to passing law school, and then we'll come to that later. I'll do a more intensive session on that.
Sure. But
then for the M, that is the SMART. The M stands for mentorship. As I said, you need to get a mentor.
Naturally.
Because people enter law school without knowing a lawyer who can easily spend time to take them through the course. So a lawyer with the practice, the lawyer has the experience. So when you have difficulties in contract, a lawyer can give you like certain contracts to read so that you'll be able to relate with the theoretical aspects. Remember, as I said, the law school, the LLB is theoretical.
Yeah.
Contract law would be read. So you read contract law without actually drafting a contract. You read contract law, the principles, without actually being allowed to go out there to draft contracts for people, because you don't have a license to do so. So how do you get the practical experience? You can talk to a mentor, someone who spent time to take you through these things. So when you have issues with your time management, when you have issues with the law being overwhelming and all that, then you can contact your mentor.
Right.
Even sometimes financial difficulties, a mentor can help you out with that. I hope you got me. Then the A in there for the SMART, the A stands for the authorities. Now, as a law student, you should be able to identify the actual authorities for each course. That's why you are granted the course outline.
Yes.
And trust me, people say, well, they don't read the cases, all the cases on the course outline, because the cases are a bit much, or the textbooks are a bit many and all that. Now, the issue is that you should learn how to extract the authorities. Now, to teach people how to extract the authorities will actually take a long period of time. But I'll just emphasizing that you should learn how to read. You should learn how to open the book and go into detail, find what you are looking out for. So attending lectures is very important,
Yes.
right? Because the lecturer would actually direct you into which particular authorities are essential. So for contract law, you know that when you buy a textbook, you could quickly glance through and know that, the principle is here, the authority or the case is here.
Yes.
You get it? So in that sense, you are learning how to derive the authorities from what you read, and it takes a lot of experience. So law school is more or less sitting down for long periods of time to read and extract the authorities. And then the R in there also is related to the authorities. That is for research and reviewing. You know already that if you are going to answer tutorial questions, if you are going to do assignments, legal assignments and all that, there is a lot of research that needs to be done, right? So you have to even know how to do the referencing, the scholar method. So there are so many details in there as to which particular materials you need to read, which particular materials you need to reference, especially in the written aspect of the law. So you'll be doing a lot of maybe thesis, a lot of paperwork, a lot of presentations, a lot of assignments where you have to write and reference. You have to know how to reference cases. You have to learn all these things. So you have to learn how to research into all these particular aspects. And then the T is actually the time management. Remember, SMART is SMART. So T is time management. That's the priority in there. And everyone is a different individual. So you must actually learn how to focus on studying, how to apportion the time to study the particular courses. It's very important to note. So when you study these courses, right, and you are actually balancing it with work, you are balancing it with maybe other studies, you are balancing it with family life and all that, people will tell you that the law course is a jealous course, right? The law course is very jealous. So in that essence, you would have to know how to prioritize your time. You have to know how to make sacrifices. You have to cut off certain things that you know for now will not basically help you to enter help you to study the law effectively. I hope you got it. So that is very, very essential to note. So in that aspect, you are just focusing all your energies, streamlining your energies into studying the law, right? That is having that priority with your time. Then there is the cane method. So a smart cane. The C is for case briefing. Now you enter law school and people are like, oh, how do we brief cases? Because you are going to meet a lot of cases.
Oh, yes.
There is the to find attorney general. I think I saw a post of yours. You said your favorite case was it Gla in the Republic. Which case was?
It was, I remember currently in Legon, we are doing this challenge. Like every day there's a particular challenge. And everyone's like, oh, what's your favorite case? And it's like, this is law school. Like there's no one favorite case. So I decided to do this thing where for each I'm currently in my second year in the 3-year course. So for each course that I'm doing, it involves either the locus classicus or like the essential cases.
Wow.
So for criminal law, for instance, you have GLA in the Republic. Obviously, even there's no way you are a law student in Ghana, you don't know to for an attorney general.
Yeah, that's true.
So and to add to the case briefing aspect, one thing, because for each class you have like 10, 20 different cases.
Yeah.
And obviously, what time do you, given maybe your schedule, because I work during the day and then I go to school. So it's like, what time do I have to be reading like full cases? So I would decide that maybe for like the locus classicus, that's when I can read like the full-on, the detailed case, and the rest I just look up like the case briefs.
Perfect. So case briefing is actually another whole entanglement that you have to deal with.
Yeah.
Because of the fact that sincerely you cannot brief every case because you are going to have a long line of cases, so you cannot sincerely brief every case. That is the truth. So you have to even learn how to brief cases. Now when I started law school and the case is like 30 pages or 50 pages, I'll get overwhelmed. But now in practice, you meet a case that is like, in your research as a practitioner, you meet a case that is like 100 pages and you are like, oh, I can brief this case in like 3 hours or 2 hours. Something that will take me the whole day or even 2 or 3 days to brief because I have to read 100 pages. Now it just takes like 2 or 3 hours. Now you learn what to look out for. You learn how to extract the facts, how to find the issues. Now lawyers and the judges help us a lot. They even state the memorandum of issues. So when you're reading a case and the judge has stated the issues, you are like, oh, thank God. Like you are done because the judge has raised all the issues for you. So you get the issues and then you quickly need to know how to drive out the obiter dictum. You have to now quickly rush and find the ratio decidendi. The reason, the legal reasoning. And it's a lot of experience because if they are reading a judgment and Lord Denning is there, even if Lord Denning is the dissenting opinion, you still have to go and read his statement because he's a renowned judge. So from experience, you have to know like which judge is actually like really good. Some judges are like really good. You want to really read their statements, especially if the person is a chief justice or if the person was the presiding judge, especially if it's a Supreme Court decision. So in essence, you have to start learning how to read cases and how to brief cases, find the facts, find the issues, and find the facts, the procedure, the issues, raise the holdings, the ratio decidendi or the reasoning, and then maybe conclude and even try out some dissenting opinions and all that. So case briefing is also so important. And after the case briefing, the other A, I usually relate it to attendance. Now, the issue with attendance is that you must learn how to attend every session, especially the seminars, you get me, the co-curricular activities. This is very, very important. So with these co-curricular activities, the extracurricular activities, I usually call them co-curricular activities. They are extra courses that you have to take. So what about the mooting? What about the debating? What about even the social hangouts and all that? You need to really attend all these events because I met my mentor at a social hangout where some lawyers were come to speak to students, and then I met him. I was like, oh, I'm in level 100 and I've been really struggling. So teach me. I was like, oh, learn the smart game method. So I'll send you some materials on how to study, how to prepare study guides, how to do research, how to brief cases. So just on that day, I got a Google Drive with all the materials. I was like, oh, okay. So in one day, I could actually learn all these things. But because I never met a mentor, I didn't know how to brief cases properly. Because no lecturer will teach you how to brief case. No lecturer is going to sit by you and say, okay, let's read the case together and brief it. No. So they'll just reference the case to you and you're supposed supposed to learn how to read it and brief the cases by experience. So you get how frustrating law school can be when you don't really know your way. And so the next thing is, as I said, you have to attend every seminar, you have to attend every law program, you have to attend every social hangout. You have to do your best to attend these things, especially where mentors or seniors are coming to give speeches or even conferences and all those kind of stuff. People will just be invited and they'll say if there is no item 13, they are not coming and all that. But the item 13 should be what you are come to learn or what you are come to take from that particular program. I hope you got it. It's very, very important. So the N is actually related to the A. The A was for attendance and the N is for networking.
Right.
There's a difference between someone who attends the programs and the seminars and the courses, right, as compared to someone who actually does the networking. You can attend the program, finish and leave, right? You can learn from the program. So you can attend a course on how to do mooting, you finish and you go. But then there are some lawyers who came to train us on how to do mooting. So if I had attended the conference and I left, I wouldn't have had a network. But because you attend the conference on mooting, although you've learned everything about mooting, when you are leaving, why don't you approach the lawyer and say, hello, I learned a lot about it. Can I get your contact? Can I email you? Because I'm really interested in being a good advocate. And I realize that my oral skills are bad. And the lawyer will just be like, okay, take my email. And that is the networking. So there's a difference between attending events and networking. You have to learn how to get contacts of people. By the time you finish law school, you have to know like 50 or 60 lawyers on your contact list. Because when you're struggling, there's a lawyer that can help you out, but I really don't know, especially when you're looking for a place to do your internships. Right. Some people have never stepped into law firm in their first or second years, or even their third years. You have to know some law firm that when you step there, they're like, oh, that's my lady, that's my friend. Oh, come. So you have to have that social relationship with seniors. Because this law practice, the seniors are the ones who are going to help you. Yes. They are the ones who are going to teach you. They are the firms that you apply to and all that. I hope you got it. So it's very, very important to note. And then the final one is the E. So it's Smart Kin method. So it was CANE. So that's the case briefs, the attendance, the network, and then the E is for examinations. Right. You have to learn how to write exam. That thing is even a whole different dilemma on its own, writing an exam, because you can be a good law student and then you are supposed to answer some questions in 2 hours or 3 hours. Yes. And now it now tends to be more or less an examination of how fast you can write. It's not really about what you know, it's how fast you can write, how fast you can reason, how fast you can analyze stuff and all that. I hope you got me. So the exam, learning the IRAC method. Yeah. People still struggle with IRAC. That is the issues, the rules, the application, conclusion and all that. Yeah. So you have to learn how to use the IRAC method to answer questions, especially the problem questions. Oh, yeah. You have to learn how to, get the issues out of the problem questions. The issues are the matters in contention between the parties. So you read the question and you ask, what is the dispute between the parties, right? What are you supposed to extract from this particular problem question, right? You have to even know how to identify the area of law. Yeah. Right? But when you get the area of law wrong, you're actually switching or you are just diverting from the entire question. You get everything wrong. So you have to even know how the examiner is going to mark you. So you have to know how the examiner expects you to answer the question. It's not about showing off what you know. It's showing off what they expect you to know. Yeah. You get it? So if the examiner asks you a question on which question have you recently answered?
We recently did a torts exam,
and which particular area of law came in and all that?
Funny enough, I remember there were 2 questions. One was on battery and one was on assault, but I think they were both essay questions.
Oh, okay. So they're both essay questions. Yeah. So as a practitioner, maybe you've not done a battery case in like 3 years, but often you know that, when the examiner asks you a question on battery, you are supposed to remember the 6 elements of battery.
DV slip.
Yeah, I hope you got it. So you are supposed to just know that, there must be a direct act, physical contact and all that, voluntary act, the state of mind of the defendant, lack of consent and all that. It must even be a positive act. Yes. So already you realize that between the 2 of us, you are able to get the 6 elements of battery. A student enters and he realizes that he doesn't know the elements of battery, but he understands battery. Right. You get it? So it's not about your understanding of battery, it's how you are able to memorize the elements. Because if we can mention it, that means we know. But maybe you don't know. Maybe you just know the elements. But the lecturer will assume that once you're able to mention the elements of battery, then you know what constitutes battery.
Right.
I hope you are getting me. But if I really know battery well, I've memorized all the cases, but I don't know the elements. Maybe I just remember 2 or 3. What happens is that's it. I cannot really express myself. I hope you are getting me.
I get it.
So when you go there are the elements that you have to look out for malicious prosecution, for false imprisonment, for unlawful arrest, and tort law.
Trespass to chattel,
trespass to land, and all that. So the elements are really, really critical. So that is it with examination, especially with essay questions. You're also supposed to really know how to identify the topic sentence, what they expect you to write on. You don't go around the bush, like trying to beat around the bush and trying to like talk about everything. Just go straight to the point, answer the question, get the topic sentence, inform the lecturer as to how you are going to address that particular topic sentence, go into the first, second, third paragraph, address the law on the matter, conclude, give your opinion or give your advice, or write some nice conclusion, attractive conclusion, because these examiners will read your introduction, then they can even skip and read your conclusion. You get it? So you then even have to underline your authorities.
I do that a lot.
You do that, yeah. So
because this fun fact, like when I have those like felt tip like pens, they're not like felt tip pens. So what I would do is, after I'm done like answering the questions, I go around and then I underline, not only underline, but I kind of like darken them. It's like so that's
well, that's interesting. So me, I would underline. I didn't have a. I'll just blam. Like I'll just scratch that line underneath the case. So I write the name of the case, Blind the Republic. I'm just bolding everything. So the lecturer will see that at least I've written that case. The fact can be wrong, but at least he knows that, I identified the case. Because they are also having a lot of students, so they might just be flipping.
I took that into mind. Because I remember our criminal law last year, our criminal law lecturer was like, she was the one who told us to underline the cases, because there are a lot of, like my classmates, for instance, were like, almost 200 of us. So it's like, imagine grading all that, and it's like, okay, how can I tell if this person has stated a case or stated the statute or the authority in question? So that's why I came up with this strategy of like, with my rule and then my low felt pen. I don't know. Like those. So
you just underline and then make sure that you are helping the lecturer. Because the lecturer actually will appreciate someone who has a nice handwriting, who is making things easier for her to read.
Right.
I hope you got it. You underline it, you have a good handwriting. You don't just scribble.
Exactly.
I hope you got it. Then you are good to go. So this is the smart scheme method. And I feel like if I've informed people about the smart scheme method, people are like, okay, so these are the things I have to focus on to be an effective law student. You have to learn how to prepare your study guides. You have to learn how to learn how to relate with a mentor, get a mentor. The A is for the authorities and all that. The research is the R. Then I think the T is the time management. So the C stands for case briefs. Perfect. There's another A that stands for attendance, and then the N is for networking, and then the E is for the exam. So these are the key things that we have to learn how to deal with. You have to focus. Every day I wake up and say, what is my smart skill for today? If there's an event for today, my smart skill will be attendance and networking. So I'm coming to do attendance, I'm coming to network. If tomorrow we are writing a paper, then my smart skill is how to prepare a study guide, how to do the revision, and how to answer past questions and apply the IRAC method and all that. So this is how you become an effective law student. It takes a period of time. But then when you apply these things consistently, you realize that, okay, there's some significant growth in your study of the law. So that's how.
So Seth, as a law student myself, being in the system, seeing how stressful and difficult it is, also considering the different career options, do you think that the study, someone will be dying to ask, is the study of law worth it? And also, what are the different career options that I can venture into? Because I hear of people who after the LLB, they don't go to Makola, they don't practice at all. They just have like a law degree in their back pocket.
So it's really what you are going out for. The study of the law is worth it if you know what you are going out for. If you are going out for money, trust me, in this country like Ghana, when you get out there as a lawyer within your first year, you're not going to make tons of dollars or thousands of CDs, bam like that. No, you have to even know the particular law firm that you're going to work out and all that. And you get it. So You have to know the particular law firm that you are going to work at. So basically, the study of the law is worth it if you are able to plan your life out, plan your career out,
Right.
to determine the particular resources that you are going to achieve or the particular investment that you are going to make. So in essence, depending on the career, there are some law courses that are actually worth more than others. You have to know the country or where you're even going to practice these particular law courses. You go to certain foreign jurisdictions, you can even be called to the bar in certain foreign jurisdictions.
Yeah.
Like with your law license here, you can go to Canada, go through their NCA process, and then be called to the bar over there. And that place, their estate law, their corporate law in the United States of America, their corporate law is very, very intensive. So you can make a lot of money from there.
Right.
Ghana, if you are looking at the law courses, if you study land law, you are looking at land litigation. If you study commercial and corporate practice, you are looking at commercial and corporate litigation. If you study criminal law, you want to be a criminal lawyer, you can specialize in that. So it depends on the career option you are looking out for. Some genuinely actually are of higher value than others. People who are doing divorce cases and others may not be getting much as compared to those who are into the commercial practice.
Right.
But it really depends on how intensive you are going into and how intensive you are. Let me say, but it really depends. Are you making a signal? But it really depends on how intensive you want to. How do I put that phrase? Let's see. So you can cut it out. But it really depends on how intensive you are going to invest your time and energy and resources, because there are other options you have to consider: your time, your family, your social life. If you want to sacrifice your mental health to become like an extraordinary lawyer, you can do that. That means you'll be working 12 hours a day and you'll be like overusing yourself and overusing your resources and all that, but then you get lots of financial benefits. So when I tell students that there are really good career options out there, I usually tell them that, look, the law provides opportunities for making money, and it's so important to understand that law provides a variety of opportunities for making money. And when I say variety, every particular course is a money-making field. So you come to law school in your first year, you're studying constitutional law, Ghana legal system, contract law. You can be a commercial lawyer with good contract skills, and that is your specialization. Or you can just specialize in constitutional law. So you can be a very, very recommended, a very, very renowned constitutional law lawyer. I hope you got me. So in that essence, when you go to your second year, you are studying criminal law, law of torts, and then probably public international law, as well as land law or immovable property law. I hope you got it. So you can specialize in those fields in the future. You can decide to be a very good land litigator, a very good real estate litigator, a very good construction litigator, a very good public international lawyer. I hope you got me. A very good criminal lawyer. And then in your third year, you're looking at natural resource law, environmental law. You can be a very good mining and minerals lawyer. I hope you got me. So you can really focus on what your interests are and specialize in it. So there are so many opportunities out there. Apart from the formal career options like the corporate litigation or litigation and solicitor practice, you can also look at being in academia, being a law teacher or a law lecturer, being a law mentor, taking these particular extra courses like your master's immediately, so that you get the necessary specialization to be a law lecturer and all that. So then you are just focusing all your career options into teaching the law and training other people in this legal field. I hope you got it. So it's very, very, very important to know that there are also academic or academia options available, especially those who find the litigation intensive, like being a solicitor or being a barrister. It can be very, very intensive. There can be a lot of work at the same time. So if you want a sort of relaxed model where you also have a bit of more flexibility and control, you can also go into academia. Then another thing you can also go into is basically what is known as in-house. So that means you are not doing the litigation. You are just basically working for a particular company as their legal advisor, like or their company secretary. Yeah. So in that essence, it's more or less like office work. You are reviewing their contracts, you are reviewing their documents and all that. So you are trying to determine whether or not they are conducting themselves or conducting their business in accordance with the law. So company secretaries, etc., can be in-house. Company secretaries or business lawyers can also be in-house. So people actually try to debate or consider which option is better, whether or not you'll be in-house, you are just working for a corporation or a firm, you are taking your good money, or you'll be doing the litigation, trying to handle a lot of cases at the same time, trying to handle numerous clients at the same time. There's also good money in there. And then another option is actually social practice or social work. That's the NGO and all that. It's actually a huge field for lawyers, because anything that is dealing with, let's say, climate change, where you are going for international conferences on climate change, human rights, you can just set up your own NGO, try to address the needs of underprivileged in society, try to provide certain legal aid to people and all that. You can build your entire career on that, and it can really take you very far. People think that NGOs are not profitable per se. It's not about the money, it's about the investment you are putting in the lives of others. And there are so many opportunities you can derive from this particular social work, attending international conferences, networking, and even getting funding and all that. So there are really many career options. As I said, they are divided into 4: litigation, in-house, academia, and NGO or social work. So if you find out that, oh, I'm really good at social activities, I'm really good at advocacy and litigation or mooting, I'm really good at trying to just sit at one place and be reviewing contracts, then you choose what really works best for each of them. So I think you have to take a more intensive tutorial on the particular career options out there, because going into the law, you might think it's not worth it, but then there are so many opportunities out there and there are so many diverse interests. But if you are going there to make money, then no, it's not worth it, because the school fees you are going to invest and the particular, the time, the energy, it's a 5-year, 6-year thing. So you are going to invest a lot of money paying fees, you are going to invest a lot of resources into it. So in that essence, if you are comparing the money you are investing and you want to get money immediately, then it's not really a good option. But if you want to build your legal career, you want to enter into diverse fields, especially providing legal services for people and trying to settle the problems of people and all that, even ADR, alternative dispute resolution, I even feel to mention that arbitration, mediation, conciliation and all that, it's also becoming a wide, diverse field, especially international arbitration and all that. So many people have issues, many people have problems that lawyers have been trained to settle. You just have to find out what you're really good at, and that will be really worth it. When you combine your passion or your interest in settling that particular dispute between the people, so you are combining your passion and your legal career, it's really smooth. My passion is mentoring people, so even in litigation I still try to make time, have a flexible schedule to mentor people through podcasts and taking videos or trying to raise training programs for students, especially with the master class and all that. So you realize then that it depends on what you are interested in, because people ask me, oh, so don't you get tired, don't you get overwhelmed? And I'm like, I have flexibility, I'm doing what I like at the pace that I like, so it becomes something that I have a bit more control over. That's really it. So you have to really learn how to combine your interests and the particular career options that works for you. I think that is it.
Okay, so thank you so much, Seth, for your time and for such an intensive conversation. I have learned so much, especially with the smart cane method, and also knowing the different career options that are out there, not just for me, but for other future lawyers once we step out into our future legal careers. And we really appreciate and we look forward to more conversations and insightful.
I also look forward to holding more conversations with you. It's been very fruitful. I just want you to take this from whatever you've done so far, that the study of the law is not difficult. And if you are really passionate about practicing law, there are so many diverse fields out there you can generate interest in. Many students give up on their way, and it's really sad to see. That's why we are trying to hold a lot of mentorship programs for students, because it is hard, yes, but there are certain approaches that makes things easier. So thank you for also hosting this session. It's been really enjoyable. I hope you have a wonderful day. Thank you.
Too.